I think the Reynolds family likes you a lot.
How do you explain that? The genetics?
They've taken a liking for sure, and I'm very grateful. I mean, I don't think I could literally have anyone better in my corner, and they're just they continue to blow me away with how just real they are and how kind they are. And
Hey besties, welcome back to my channel. Blake Lively is terrified that her case is going to get tossed. That's the only way that I can describe what was filed in court last night after I uploaded another video where we were talking about her motion for treble damages under 47.1. Yesterday, her attorneys filed a request for a denial of the motion for judgment on pleadings based upon it being untimely. And then if they don't do that, then give her an extension of time. On the face, the very first thing she asks is for a denial. So it seems like it's an entire opposition, but instead it's not. And they want the judge to give them almost a month to respond to this. They write, to be clear, Miss Lively is prepared to respond to each of their defendants' arguments at the appropriate time, whether that be at the summary judgment state or at trial. But the Wayfair defendant's decision to sit on these supposedly meritorious arguments for nearly 9 months means that the briefing and adjudicating them now would only lead to duplicative briefing and waste judicial resources and would force Ms. Lively and the court to bear the burden of the Wayfair defendant's delay. Tellingly, each of the Wayfair defendants' arguments have been available to them since the outset of the case. And although their counsel alluded to the possibility of a motion for judgment on the pleadings on the record at the conference held on July 30th, the Wayfair defendants waited to file the motion until the response deadline would fall on the last day for depositions in this case, knowing full well that because of their own discovery deficiencies, Ms. Lively's counsel would be preparing for and taking depositions of 4 of the defendants during the period. Meanwhile, by the time the motion is fully briefed, the deadline for the summary judgment motions will only be days away, meaning that each of the fact-bound challenges to the pleadings raised in the motion will be overtaken by the record evidence in the summary judgment stage. What they're trying to tell the court is that there are arguments of facts in their pleading, not arguments of law. A judgment on the pleading is not arguing facts, and there's really nothing in their motion for a judgment on the pleadings that suggests there is a fact issue. In fact, it tells the court in their document that they're taking her allegations as fact and instead are looking at why the pleadings aren't allowed. Their claim that this is untimely and late is false because a judgment on pleading can only be filed after the pleadings have closed. Blake Lively, by her own admission in the same document, tells the court that she had to file multiple complaints. She filed her first one on December 31st, her second one on February 18th, and then her third, which was the second amended, was on July 30th, 2025. When you do a judgment on pleading, it's after the pleadings have closed. It's different than a motion to dismiss. It's not the same as a summary judgment, and it's only allowed after the pleadings closed, right? So if she filed her response, right, her second amended complaint on July 30th, they had 2 weeks to respond on August 13th, and then her response to that would have been due a week later, which would have been the 21st or the 20th of August, meaning they didn't really delay here. It would have taken them quite a bit of time between their depositions and everything else to do this judgment on pleadings, and it's only 6 weeks after they filed their answer. You can't file a judgment on pleadings until after your answer. Now, in a footnote, and judges don't make rulings based on footnotes, by the way, they tell the court that Wayfair is so sloppy because one of their pleadings was that they hadn't exhausted Title VII, okay? And they're claiming that this lies with defendants and operates as an affirmative defense. Not only does that render this argument inappropriate for resolution on a defendant's Rule 12 motion, i.e., it ends with us did not even raise this affirmative defense in its answer. In other words, not only did IEWUM move for judgment on pleadings based on an affirmative defense it had not pleaded, but because of that failure, she would be entitled to judgment on this particular defense, not them. In any event, the further demonstrating wastefulness, Miss Lively amended her CRD complaint and received a right to sue letter with respect to IEWUM during the pendency of this action, as well as established in this district. That is sufficient. They don't say when they got that amended CRD. And by the way, I have a copy of her original CRD because we did an FOIA, and you can't amend a CRD because it was closed. When she filed her CRD complaint, they closed the action the exact same day. You don't get to reopen an action once it's closed. They would have had to file a brand new action with the California Civil Rights Department. And then she would have been required to provide a copy of that to Wayfair. I highly doubt that they would be asking for this to be dismissed if they had received this right to sue notice from Blake. And say she did it last week after she filed this. That's more than 300 days after the last incident of harassment, far more than 300 days. If she just updated it now, it's not active. And then if she didn't provide that to Wayfair, that's on her, not on them, because they actually provided a copy of the CRD complaint as an attachment, the one that she provided to them in discovery. So I'm really wondering and questioning when they claim they amended this. They spend a lot of time trying to claim that this is going to delay the trial. But they also say that the question at this stage of this case is not what the pleadings allege, but what the evidence shows. And the appropriate means of answering that question is through the motion for summary judgment. Meanwhile, to the extent the motion raises purely legal issues, that would not be affected by the summary judgment evidence. They will suffer no prejudice from a few weeks' additional delay in briefing those issues. So, on the one hand, they're telling the judge they have no merits, they have no grounds to do this, they don't even get to make these claims. But then on the other hand, they're saying, well, even if they delay this to the summary judgment, they can make those claims at summary judgment. But if it's a pleading issue, it's a pleading issue. It doesn't matter, and it doesn't have to technically wait until summary judgment. Summary judgment allows someone to bring in all of the evidence from discovery. They can pull from the documents provided, they can pull from deposition testimony, they can pull from, text messages, contracts, video evidence, whatever it is, to make their, this is why we should win. And it's fair to say that both sides are going to seek a summary judgment. That's pretty standard. Summary judgments allow you to bring in the evidence. Blake claims that she wants to bring in more evidence, right? Which is wild, right? And she has more evidence now that she can make and amend a new complaint, but discovery has closed. And that's what she's mad about. Fact discovery is scheduled to conclude on September 30th. That means fact discovery is over as of today. They are going to be doing a couple depositions, and then they have expert discovery that they're going to be working on. What she's mad about is that fact discovery is over, and now they want to get rid of this case. The truth here is that I don't think they want to actually answer to it because I don't know that they're going to have a response for it, because there's nothing in here that even discusses the FEHA claims. It discusses the right to sue letter, but not the extraterritorial application of the FEHA. And by the way, I went to the California Civil Rights Department website, and a right to sue allows you to sue in the state of California. A California right to sue, not a New York right to sue, not a New Jersey right to sue, but a California right to sue. Blake Lively knows that she got a California right to sue and then willingly brought it to New York when she should have brought it to California. They bring up that the federal civil rules provides that a party may move for a judgment on the pleadings after the pleadings are closed, but not early enough to not delay trial. This is not going to delay trial. In general, if a party engages in excessive delay before moving under Rule 12C, the district court may refuse to hear the motion on the ground that its consideration will delay or interfere with the commencement of the trial. It's not going to delay the trial. And in fact, if he doesn't consider this, it could mean bringing a case to trial that's not even legally sound. This is actually more cost effective for a court to look at it now, to determine now if based on pleadings any of this is allowed. Because if you get to trial and none of this is even allowed, it just wastes time, resources, money, and taxpayers' money. They say that the motion is untimely, although all of the arguments have been available to them since the initial complaint was filed. They did not raise them until September 26th. Measured against the court's stated goal of managing this case to a March 9th, 2026 trial date, the delay was excessive under Rule 12C. I don't think it was actually excessive because Jed Wallace did a motion to dismiss. They have an extremely tight deadline for discovery. And I might add that a complex case like this to go to trial in March after a year and 2 months in federal court is ridiculously fast. With the number of defendants, the number of depositions, and how quick they wanted this to go through, the even concept that the expectation or the first trial date would be the trial date that you get is asinine. Most federal cases trial dates get pushed more than once. The motion raises fact-bound challenges to the sufficiency of the SAC's allegations. That is not true. Telling a court that the FEHA don't apply extraterritorial is not fact-bound. That is actually legal. That's a law. Fair report privilege and litigation privilege, which are for the defamation claims, are law, not fact. Civil conspiracy falls apart if everything else goes away. That's law, not fact. Everything they're asking for is based upon law. Those arguments are meritless. It's weird because they don't even bring up which ones are. But as far as the timing of the motion is concerned, there are more importantly all but moot. At this stage of discovery, she has uncovered voluminous evidence relevant to all of her claims. Rather than merely defend the sufficiency of the allegations to respond adequately to the motion, Ms. Lively would need to make a proffer of the new and more detailed facts in her possession that would entitle her to amend the complaint should any of the Wayfair defendants' arguments prove successful as to any of the SAC's claims. The fact that they're suggesting that they want to amend their complaint and be given amends because they got more discovery is insane, because it tells me that they're actually worried that there's meat here and that there's grounds here for these to be dismissed. And the evidence is irrelevant if the pleadings aren't allowed legally. If they want to have the FHA claims apply, they should have been filing this case not in New York, but in California. But they didn't. And then if they get to amend their complaint, guess what? That opens discovery up again. And it doesn't matter if you have all the evidence in the world. If you can't bring the claim to begin with, you can't bring the claim to begin with. The court would then need to evaluate the evidence under Rule 15's futility standard, under Rule 12b6's plausibly standard, construing that evidence in Ms. Lively's favor along with the benefit of reasonable inference therefrom. When and if the Wayfair defendants choose to move against any of her claims or defenses, she would then need to point to record evidence that construed in her favor and drawing reasonable inferences therefrom. They're telling the court that they can't win this case on law. They can only win this case on evidence, which makes no sense. It would basically be like Wayfair coming back and saying, you dismissed our case, just kidding, judge, but we now have evidence that she did these things, so you need to allow us to go to trial. It would never happen. And can you imagine the shit fit that Blake would have if Wayfair did that to her? It seeks a duplicative exercise that can only have the effect of causing delay. No. They will suffer no prejudice from having to present motion evaluated on the basis of the summary judgment evidence rather than their allegations. No, because at a summary judgment, yes, they can do pleadings, but the summary judgment actually looks at the discovery evidence. If they can get rid of the pleadings that are not permitted to go to trial, they don't have to go through the work of showing what the facts are and the agreements of what the facts are. They're only looking at if the pleading is allowed under the law. They claim that she will suffer significant prejudice from having to file what is effectively in opposition to summary judgment while discovery is still ongoing. You know how many times she has filed something that has caused delay in this case? How many motions for sanctions or for attorney's fees has this woman filed that have led to the Wayfair parties having to stop what they're doing to respond to the bullshit she's putting on the docket? Miss Lively will have to scramble to amass evidence from a discovery process that is and will be generating new evidence virtually every day between now and the response deadline, not to mention the expert discovery process that will still be ongoing. When you are working on discovery, there's always a possibility that someone can do a motion on pleadings. There's also a possibility that even during discovery, someone has a pending motion to dismiss. None of these arguments have teeth as far as the delay or the prejudice or the fact that it's going to cause her so much burden. So, here again, they're asking them to deny without prejudice to renewal of the arguments or give her more time to respond. And they want them to be able to respond only 5 days from the day that the summary judgment pleadings are due, which will delay and won't help the summary judgment. She's actually the one that's trying to delay this. She's the one that doesn't want to answer this. She doesn't answer to if these are even extraterritorial. The only thing she brings up is that she didn't, they falsely accused her of not exhausting the administration. But you know what's weird is I actually looked at records for It Ends With Us movie. And even though they say they're a California company, they opened a branch in the state of New Jersey. Wayfair actually, or It Ends With Us movie received $12 million in subsidies from the state of New Jersey, and they brought in more than $34 million to the local government and to the local community through the revenue and the work that they provided. All of the work and the location of this was done in New Jersey. So even if it's only a name that the company was formed there originally, all of the work was done in New Jersey. She's going to have a really hard time proving that she's entitled to FEHA outside the state of California and outside of the California state courts because none of this happened in California. I just think that she knows that this case could eventually get blown up, and she wants to be able to say, well, it doesn't matter. I have evidence. So even if these pleadings are faulty, I still have evidence. You know what Wayfair might end up doing is they might end up responding to this as though it's an opposition because the primary reason for that entire motion is basically to say, please just deny this because it's untimely. Don't deny it because it's meritless, and don't even describe what the meritless claims are. I think that they just are trying to find a way to get out of this, and they're throwing everything at the judge as possible. So please deny it. If you don't, please extend time. And if you do allow it and something does get if you do permit this and some of these claims do get knocked out by this, then give us another amended complaint. You don't get a chance to continue to amend your complaint over and over and over again. If Blake had all of the evidence that she claims she had, she would have added it to the second amended complaint, but she didn't. If she really had all of this evidence, she would have done a leave to file second amended complaint to seek leave from the court. She wouldn't be doing it now. She doesn't have all of that evidence. And even the evidence she thinks she has doesn't prove what she thinks it is. And that's really the root here. Retaliation has to be pled as actual retaliation and actual employment retaliation. If she doesn't plead that something actually happened to her that was retaliatory while she was an employee, it's not a permitted legal claim. She wasn't an employee of It Ends With Us movie at the time of the premiere or in August of 2024. At that point in time, her contract was over. Her employment was done. And as I was recording this, the judge actually made an order. Initially this morning, they said that Wayfair had until tomorrow to respond. But now he is saying instead of going back and forth and responding on this, I want you guys in my court, and we're going to talk about it in my court. We're not going to make a decision based on letters. We're going to handle this in court. So he has ordered that there will be a video conference via Microsoft Teams to discuss the matter on October 3rd at 2 p.m. They will be provided instructions for accessing the hearing via email, and the court will also provide an audio-only dial-in number on the docket for the public and press to access the hearing. So he's giving full transparency to the public and to the press so that they can listen to this, which is good. Blake was basically telling him to shortcut it and just deny it outright and say it's untimely without even any sort of like hearing. And he's basically doing a hearing because he isn't minimizing how important the motion is. and he's cutting off her attempt to frame it as a delay tactic. By doing a hearing on the 3rd, he's making a decision that he's going to decide on this fast, and that the issue itself is very serious because it's FEHA, exhaustion, did she exhaust? And then the standing damages issue. Is she even able to sue? And then did she really properly plead retaliation? So he's not going to let Blake use the docket as a way to just have a hissy fit. So they will go to court on October 3rd to talk about this, and Blake's attempt to get this denied without anything else happening and just because isn't going to work. She's going to actually have to have her attorneys argue it to the court. So tell me what your thoughts are in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and please click the bell so you never miss a video. Thanks so much for watching. Bye, besties.